Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal educational content, and today may be the day I earn your subscription. For today's live stream, we're doing a group of stories for future daily releases, or at least some of them will become future daily releases. Yes, it is batch record. Why not tomorrow? Because tomorrow I have to do stuff for my day job, which I really hate. And don't want to do anymore because it really makes me sad in a very non-ironic way, I assure you. But alas, I have to, at least for the moment, and so yeah. Anyways, we're going to do some story recording tonight, and if time allows, maybe we'll do some stuff tomorrow. But first, we will begin with two announcements. First of all, a friend of the channel, Stephanie, is starting her own channel. So this is her Instagram. And this is her Instagram page. Lockificent Layer is the name of her Instagram and her YouTube page. Her YouTube is not yet live. She's planning to make it live tomorrow. She'll be talking about gun stuff, firearm related stuff, and she would like suggestions on what kind of firearms you might like to have reviewed. So she's looking to start her own channel. So you can be one of her first followers at Lockificent Layer and YouTube channel, which is not yet live. But if you subscribe to the Instagram page, you will get notifications relating to her starting her new YouTube series. And of course, we wish her all the luck in the world. She has been a wonderful joy to have on my channel. I hope she'll still have time to do stuff with us as well here on Uncivil Law. It's been a lot of fun, and she wants to give it a go. I would say the same thing to her that I would say to anyone else who's looking to start this. It can be time-consuming at times. It can be frustrating at times. It can be difficult at times, but it also can be very rewarding. And so we, of course, wish her all the luck in the world and hope that it will be something that she will find to be rewarding and find something that she enjoys, and hopefully it will be the success that she quite rightly deserves. So just a quick announcement there that you can check out Lockificent Layer on Instagram, and soon to come to the YouTube. It's very exciting about all that stuff. Our second announcements. Someone is bitching about Matt, you're not allowed. Yeah, okay. No one bitches about the audio or the video, man. It just is what it is. Everyone shut up. Anyways, no. Let's see, where was I? Oh yes, the second thing is Tuesday night. This Tuesday night, we will what time should we do? We haven't picked an exact time. Shall we say 7 p.m. Central? Does that work for Stephanie? Something along that time frame. We will have our first game night. This is a premium benefit that is available to people who subscribe at the right tier at locals, and also on Patreon. I believe this is the $25 tier where I believe this kicks in. So if you are a member at the $25 tier where that picks in, 7:15 Central Time. 7:15 p.m. on this Tuesday Central Time, we will do our first game night. And we have a poll right now in the chat to determine what that will be. It will either be I Dissent, which is a card game where you argue over stupid questions, or it will be a murder mystery game. And we will host that on Twitch at 7:15 p.m. Lockificent, Loki, like Thor and Maleficent from... I'm sorry, it went away. Loki, like from Thor, and Maleficent from Maleficent. Okay, so Lockificent. I'm not sure exactly how to pronounce it. I'm sure she'll tell us all soon, but yeah, that's coming in again. No, it's definitely your fault, man. It's always your fault. Anyways, so that's going to be 7:15 p.m. at Tuesday. That is a benefit that comes to the people who don't donate at the appropriate levels on locals and on Patreon. We will make a post on Tuesday regarding how to get into those games and sign up for those games and that information will be coming Tuesday. So our first of our game nights and stuff. $25 a month. I believe that's the correct reward tier. We also are looking to allow people to buy in, but we're not going to do the buy-in this time because we don't know, or at least I don't know. I don't know what the correct price point is for a one-time buy. So that will be an option in the future, but probably not for this first game. So it will be for people subscribed at the right tier level, and we'll go from there. So if you want to remember how to sign up for these things again, it is uncivillaw.locals.com or patreon.com/uncivillaw. Locals is preferred. If you don't have a preference between the two, I do prefer uncivillaw.locals.com. We're trying to give locals some support, but patreon.com/uncivillaw is also available for those of you who are more familiar with Patreon and want to keep it going and all that good stuff. So maybe he'll have me back. What's going on here, Grandmaster Yoga? I hope Stephanie will join us again, or it's going to be a very, very sad day for Uncivil Law. But in any case, uncivillaw.locals.com or patreon.com/uncivillaw, and that will be the place for all your related needs, all that good stuff. So all that good things. OnlyFans? No, not yet. Maybe later. We'll talk, but not now. Oh man, but not now. Anyways, geez, I'm getting very easily distracted. I probably should stop reading chat because I'm having a hard time focusing. Focus, Kurt. All right, put away the chat so I'll stop distracting me. I'm just gonna put the chat away so I'll stop reading it because it's distracting me too much, and I don't have the focus energy tonight to deal with all that stuff. So what did I just do? I don't even know. Okay, great. All right, so let's do some stories. And we'll go from there. Okay, guys? All right. For today's story, we are talking about the U.S. Senate voting to disapprove the recent Biden vaccine mandates. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal educational content, and today may be the day I earn your subscription. For today's story, we are talking about the Senate, the U.S. Senate voting 52-48 to strike down the Biden vaccine mandates as it relates to mandatory testing and mandatory vaccines. This is a mostly symbolic move for reasons we'll discuss, but we'll discuss it anyway as we get started with this story. So we're picking this up from the Huffington Post. The Senate voted this past Wednesday to reverse the Biden administration COVID-19 vaccine or test mandate under the OSHA mandate. So this is reversing, by congressional action, OSHA's adoption of the vaccine mandate. A GOP-led effort against public health measures designed to bring about an end to the pandemic. The 52-48 vote amounts to little more than a symbolic rebuke of the policy, which is tied up in courts anyway in order for it to succeed. The resolution would also need to be approved by the Democrat-controlled House and signed by President Joe Biden himself, neither of which is likely. So yeah, this is an unfortunate aspect of this, right? So this entire process came about as something called the Congressional Review Act, which was passed as part of Newt Gingrich's contract with America way back in the mid-90s, right? So one of these reforms of government. So what this Congressional Review Act does is it allows Congress within 90 days to pass a bill to undo the mandate and then it has to be signed off by the president. Now, the whole thing doesn't make any logical sense because Congress has the power to do this anyway. Congress, bill beats regulation, right? So Congress gave themselves the power to within 90 days review a thing an administrative agency did, and within 90 days reverse it, as long as it was passed by both houses of Congress and signed by the president. Here's the thing. The whole 90-day thing is irrelevant because Congress has the power to just do that anytime. It's actually illegal for Congress to restrict its own power. Congress can't restrict its own power because Congress's power flows from the Constitution. So it can't pass a bill that says, oh, we can only do this within such and such a time period, or we need like a supermajority to undo something. No, they can't do that. It doesn't make any sense. I suppose Congress can pass a bill that says they need a supermajority to change the bill, but it wouldn't make any sense because the Constitution itself says you need a majority. And so you can't have a bill that says you need a supermajority because the Constitution says it's a majority. And the Constitution beats statute. Congress can't restrict its own power. So the whole thing is silly. First of all, because the 90-day limitation doesn't make any sense. So on day 91, the Congressional Review Act, I guess, doesn't apply. But you know what does? The Constitution. And second of all, the whole thing's a little bit silly because they need both houses of Congress and perhaps even more importantly, President Joe Biden's signature. The president who's in control of OSHA. The president who, if he wanted to, could just undo OSHA because they respond to him. So, you know, I suppose if you get 2/3 of each house, then you can do it through a veto override, but you can do that anyway. So the whole thing is a bit pointless. But they had a vote on it anyway. The Biden administration says if the bill reaches the president's desk, they would strongly recommend they veto it, which, you know, why wouldn't they? Because if they were in support of it, they could just basically call up OSHA and be like, hey, you're OSHA and you are accountable to the Department of Health and Human Services. And you know who controls the Department of Health and Human Services? That would be me. So you're going to undo that now because I own you. So, yeah. Last week, a group of conservatives in the Senate almost shut down the government in protest of the rule, reflecting a level of animus in the Republican Party towards the continued restrictions or to the mandates or to some combination thereof. The lawmakers ultimately relented after winning 0 concessions from the Democrats, allowing it to be fully funded. Yeah, so they threatened to not fund the government unless this thing got passed, but the entire thing is pointless, so who cares? We lost the battle, but we're going to win the war. You are not going to win the war, no. I think it was a huge victory, though, in the sense that all the Republicans stuck together, that we all voted together. You could have just written a memo. It would have been equally successful. Marshall said that he'd like to see a pause to urge people to get vaccinated for COVID-19, even though he called it immoral for the government to ask them to require it. These are different propositions. I did note, however, that our friends at Merriam-Webster Dictionary recently redefined the term anti-vax. They redefined it like this week. Now, you might remember this happening previously when Amy Coney Barrett was before the United States Senate and Senator Hugh from the great state of Hawaii asked them about sexual preference, or because Barrett had said sexual preference. And Senator Hugh said, oh, sexual preference is offensive because it implies it's something you could choose. And you know what happened later that very same day, within like 4 hours? Merriam-Webster changed the definition in the dictionary, right? Earlier that day, it didn't say it was an offensive term, but you know what happened later that same day? Merriam-Webster now said it was an offensive term. So they redefined the term sexual preference in real time to support the senator from Hawaii's question. How fun. And Merriam-Webster has done this exact same thing now with the term anti-vax. Anti-vax has now been defined to mean anyone who opposes vaccines in general or who opposes vaccine mandates. So apparently if you oppose the mandates, you're now anti-vax too. How strange. The term has been redefined before our very eyes. Well, that was convenient, wasn't it? You don't want to get this Omicron variant. You don't want the Delta variant either, so please get your boosters. To the best of my knowledge, 0 people have died from the Omicron variant anywhere in the world. I mean, I couldn't absolutely swear to it, but yeah. Pleading with the public to get vaccinated to protect themselves and their loved ones hasn't worked. So therefore, we're going to mandate it, which Biden himself said he wouldn't mandate it. If you remember that far back, when he was running for office, he said he didn't have the power, but he would encourage people, he would extol them. And now he's like, how about the mandate? Okay, and then apparently there's a growing gap in vaccination rates between Democrats and Republicans, which, whatever. The emergency OSHA rule required employees with at least 100 workers, because if they only have 99 workers, the virus doesn't spread. The virus doesn't spread if you only have 99 workers. The virus only spreads if you have 100 workers. So that's why the regulation only applied to 100 workers or more. If you have 99, the COVID doesn't spread. It's 100 to party in COVID land. The rule doesn't force anyone to get the vaccine to keep their jobs, but it gives employers the option to mandate vaccination if they choose. And also, if they don't, requires the employees themselves to pay for the testing, which can get quite expensive, and of course is run to roadblocks in courts. And opposition, of course, is not entirely from Republicans, but the ones that broke were Senator Joe Manchin, which is absolutely no surprise, and John Tester, which is a bit more of a surprise. But those are the ones who split. And the one from Montana, or the one from Missouri, I apologize. No, Montana was right the first time. The one from Montana said that unlike the Biden administration vaccine requirements for federal contractors, health workers in the military, the OSHA rule put the burden on businesses in his state. So he wasn't in favor of it. So, yeah. And then, of course, Chuck Schumer, being Chuck Schumer over here, is all in favor of it and says that anyone who wants to overturn it is anti-science and anti-vaccine. As it turns out, Schumer is now right. Anyone who wants to overturn the mandate is, in fact, anti-vaccine, because Merriam-Webster themselves has redefined the term. So anti-vaccine means anyone who opposes mandates for vaccines. So now he is definitionally right due to the new exciting definition brought to us by the Ministry of Truth, MinTruth over here, where anti-vaccine has always meant that those who oppose mandates, and also East Asia has always been at war with Eurasia, as I'm sure you all know. So yeah. Thus, that brings us to the end of the discussion of this article discussing the Senate voting to disapprove the vaccine mandates, which is, not surprising and also kind of pointless. And also, Schumer thinks it's the greatest thing ever because anyone who opposes it is anti-vax, which suddenly has become true due to, definitions of words changing overnight. Amazing how that happened. So yeah, this is kind of pointless. But more importantly, the OSHA mandates, of course, themselves have been paused by the courts, starting by the Fifth Circuit, and they are not alone. So the OSHA mandate itself is not in force because it has been put in hold. It has been enjoined by court action. But, the Senate Republicans decided to have a vote for the record, for whatever good it does. And that brings us to the end discussion of this story. For today's story, we talk a little bit more about Letitia Stauch, a woman accused of killing her own stepson, who, perhaps unsurprisingly, is getting another mental health evaluation. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal educational content, and today may be the day I earn your subscription. For today's story, we are talking about Letitia Stauch, and a woman who was accused of killing her 11-year-old stepson, and perhaps more bizarrely, putting said dead stepson in her trunk of her car and driving across several state lines in a quest to look for a place to potentially ditch the body. It's a little bit disturbing. Also, she doesn't believe that she can be judged by the court system. She doesn't believe this to the point where she attempted to escape from jail in El Paso. And she may not be completely legally sane. So there is some suggestion along those lines, but we're getting some more evaluation. Letitia Stauch to receive yet another mental evaluation. This woman charged with killing her 11-year-old stepson will have yet another mental health evaluation. She appeared in court at a hearing on Thursday where this decision was made. Her lawyers argue she suffers from dissociative disorder, so she doesn't recognize who she is or what she's doing. And there's concerns about this played a role in the son's death, which, fair enough. If she was mentally insane at the time and she couldn't form the requisite mental state, then that might be a thing. So an attorney has noted that if the defense was able to successfully show that she has a mental condition that disassociates herself mentally from herself after the crime, that may be able to get some of the evidence barred at trial. That too, it might preclude some evidence coming in. The judge, of course, says that they don't have enough information to evaluate this question, which is one of the reasons that they are seeking yet more mental health evaluation. The judge also expressed concern about the timing of the evaluation. Stauch's evaluation is behind over 350 other evaluations the state hospital still has to get through. And the state hospital is struggling with staffing and other evaluations. If this evaluation is not complete by January 13th, the motions hearing will have to be postponed. So yeah, this is a problem for lots of different places, and also a problem for mental health treatment. There is insufficient mental health treatment available in a lot of places, and this is at least partially due to some of the decisions that were made in this country in the 80s and 90s, and even a little bit before that, to get rid of mental health hospitals in a lot of places, to get rid of the insane asylums, which was a major effort done to mainline and streamline a lot of mental health people and get them out of the mental health facilities, which may, in some cases, or maybe many cases, may have been a wise decision. Unfortunately, in my view, and I'm not certainly alone on this, we've heard as much from Democratic people as well as Republican people. This went a little bit too far. And now we run into the situation where normal prisons, to a large degree, are doing mental health care, which they're not completely set up for. And it's not really to a benefit to the prison or to the prisoners themselves. And even in places where there are mental health hospitals, and there's not like there's none, there's just a lot fewer than there used to be. And some of this is being undone a little bit, but not as much as it was in the 90s. So it's still having to undo itself. But even where it does exist, there's places that are understaffed. So they have like 350 people backlog of mental health evaluations to go through. Because there are not enough facilities. It's just that because a lot of these facilities were closed down, as I said, and where they either weren't closed down or they've been reestablished, they have not been reestablished to fulfill the need. So it's not necessarily that there's not enough people at this hospital. There's just not enough hospitals. There's not enough facilities to deal with it because of some of these decisions where it's like, well, let's get rid of the insane asylums. And, that didn't really work out that great for society as a whole through a whole lot of reasons. And so this is perhaps an extension of that in a large way, where it's just like this woman who may have real mental health problems. I don't know either way. I don't know the degree to which she has mental health problems or not. I don't know the degree to which it impacted her ability to form a mental state at the time, or her ability to be on trial now. I have no information that would allow me to form any of these conclusions. These are conclusions that require, professionals in the mental health field to provide, and then of course the judge to ultimately make the decision on, credibility and the rest of it. But the fact that we don't have the information coming into the system because of some of these decisions that were made, and some reluctance to bring it back from not in my backyard syndrome and all the rest of it, is a real problem in the criminal justice system, both as it relates to trials as things are pending, and also as it relates to punishment after the fact. The state hospital says they've been downsized in their capacity 95 beds due to staffing issues. So as it happens, this particular hospital is in fact understaffed, and there are not enough facilities, just period. We do have many vacant positions at the state hospital. A lot of these are in nursing and direct staff. We can't securely manage individuals, and that's why we made this decision with regards to the timing of things. The defense said that they plan on introducing new evidence regarding a mental health issue related to the defendant. They said the mental health defense would only apply to Letitia's actions after the alleged murder of the son. So this is a possibility, right, as well, right? So like, what parts were you mentally defective for or not? So the defense, at least up to this point, has been saying, well, we're not going to argue that she was mentally insane during the commission of the crime, but she was mentally insane after the crime was occurred, which would go to suppress, potentially, if this is ultimately successful, go to suppress any actions that she took after the crime was committed. Actions that would, for example, otherwise be offered to show consciousness of guilt, right? To the extent that after the murder occurred, the driving around, trying to ditch the body, trying to clean things up, whatever she was doing, trying to evade law enforcement, whatever was going on in that domain, right? If they can successfully argue this line and say that she was mentally insane during those periods, then that evidence, which would go to show consciousness of guilt, or attempting to flee, or even potentially her attempt to break free from jail, right? All that stuff might be excluded against her, which would, to some degree, help her defense, even if it doesn't ultimately go to the ultimate act itself. So there's the defense wants every inch and every yard they can get. So, if that's the best they can do, it's the best they can do. And that's what they say they want to do with it, which, might be tenable depending on what the mental health evaluation shows. Also, there apparently is an issue with Stauch showing up in person. So this was happening as a virtual meeting, but apparently that wasn't pre-approved. So the judge has said that going forward, she's only allowed to appear virtually if she files a motion 7 days in advance. If they fail to do so, they're going to try to bring her into the courtroom in person. So this is something that, for whatever reason, she didn't show up in person, and going forward, they say, you have to show up in person unless you file a motion 7 days in advance. So that's a thing that's happening too. And of course, this person eventually apparently drove the body to Florida, where it was eventually discovered, and faces over a dozen charges, including, of course, the first-degree murder. And she's already been found twice mentally competent to stand trial. So they find her to be mentally competent now, but whether or not she was mentally competent in the past still remains an ongoing issue. Sounds like Stauch. I don't know what that means, Stephanie. So that brings us to the end of this. Stockholm Syndrome? Maybe. Although I'm not quite sure how that would apply in this context, but perhaps. Oh, her last name is Stauch. It sounds like stock. What'd I say? Letitia Stauch? I said Stauch? Yeah, Stauch and stock. Well, I'd have to go through and re-record the entire thing now, because I said it wrong every single time. So I'd have to go through and re-record it. So what should I do here? Should I go through and re-record the entire story, or what should I do here? You fix it in post? Okay. All right. So that brings us to the end of the story of Letitia Stauch, this woman who is accused of killing her stepson, and may or may not have been mentally impaired at the time of the incident, in the aftermath of the incident, and to some degree now, although she is at least competent enough to stand trial. So there's another mental health evaluation coming down the pipe to find out the degree to which she was mentally incompetent at some period of this, and at least for the moment, that brings us to the end discussion of this case. Hold on, I need a more recent article. Oh, what bullshit is this, man? Okay, so as I'm sure many of you know, there have been tornadoes in the central and southern U.S., and I just saw that Biden decided to open his mouth and is apparently using the tragedy to push his climate agenda, suggesting storms are consequences of warming. Man, what bullshit is this that Biden is saying? All I know is the intensity of the weather across the board has some impacts as a consequence of warming the planet and climate change. The specific impact on these storms I can't say at this point. I'm going to be asking the EPA and others to take a look at that. The fact is that we all know everything is more intense when the climate is warming. Everything. And obviously it some has impact on here, but I can't give you a quantitative read on that. What a dick. What a dick. Still here, by the way. I just didn't want to. Well, I'm trying to look for this stuff. I'm trying to look for some stuff on the Valo case. I have an article from the 6th, but I was looking to see if there's something more recent on the Valo case. So give me a second while I search behind the scenes. Let's see. I don't see anything more recent, so I think I'm just going to skip the Valo case for now. Okay. Let's see. For today's story, we talk about a recent court decision that has put a halt to the Biden mandate trying to force federal contractors to get the COVID-19 vaccine. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today may be the day I earn your subscription. For today's story, we are dealing with the COVID-19 mandates. We have on this channel covered the OSHA mandates to some degree, and we have not covered to as much degree other mandates put out by the Biden administration. The OSHA mandates, of course, related to private employers with 100 employees or more, and we've covered how that has been struck down by the courts. But there was also a mandate put out for both federal employees and federal contractors, people who do work directly with the federal government. And a court has halted the mandate as it relates, at least as it relates to federal contractors. That is, people who do work for the federal government. In some cases, they're doing roles that are indistinguishable from federal employees. They just are private rather than government employees. And the courts have put a hold on that mandate as well. So we're going to cover that article and see what's happening there. The list of President Biden's executive order COVID vaccine mandates being struck down or halted by judges getting longer and longer. So yeah, this is relating, as I said, to an executive order. This is not the OSHA mandate. This is just trying to just directly do it by the White House themselves, imposing it by unilateral decree. So this time it is federal contractors getting a reprieve from these violations. This marks every single vaccine mandate being halted by the court. Well, that's not 100% true, because there is still a vaccine mandate that relates to federal employees, which to the best of my knowledge has not been put in halted, but this article seems to gloss over that fact, but that's okay. That's why I'm here as Uncivil Law, to correct the press, who, surprising no one, might have gotten this one wrong. So the judge issued a ruling listing every objection for why the mandate should be halted. So the U.S. District Court in Georgia halted the Biden administration vaccine mandate for the federal contractors, writing the president has largely exceeded the authority. The U.S. District Court for the Southern District of Georgia said the Associated Builders and Contractors, a trade group that represents construction industry, are likely correct that President Joe Biden exceeded his authority under the Procurement Act when it issued the mandate. So the Procurement Act, as the name suggests, is an act that deals with how the government procures things, how it buys things, how it pays things. So there is a act that says here's to go about how about the government can go about buying things, and he tried to issue this as a adjunct to the Procurement Act. He says, well, I have authority under the Procurement Act to do it. So as the court notes, in a practical application, it operates as a regulation of public health. It has a major impact on the economy at large and limits contractors and members of the workforce's ability to perform work on federal contracts. Accordingly, it appears to have a vast economic and political significance. The court said the mandate is costly, laborious, and likely to result in reduction in available members of the workforce. So quite a few things here, right? So this also seems to relate to what's called the major question rule. So there's this idea in law where we don't hide the ball. And when something is what we call a major question, it's not something that's within otherwise broad scope legislation. So, for example, this is one of the issues that came up with the OSHA mandate, because the OSHA regulations, as they're written, are very, very broad. They're much broader than it related to the CDC with, for example, the housing restrictions, when they tried to say there was no rent due or no mortgages due and stuff like that. It's like, yeah, no, your regulations aren't that broad. You don't have the ability to put in a rent moratorium, CDC. So that was a problem. That was a problem just of the statutory text. Like the text by itself did not contemplate anything like that. It was a total non-starter. The issue for the OSHA mandate and also this mandate are a little bit different, because the regulations, or the statutes that are in place are actually much broader. The way the OSHA mandates, or the way the OSHA regulations are written, or the way the OSHA statute is written, I should say, basically gives OSHA the authority to regulate all the things when it comes to workplace safety. It's incredibly broadly worded. So if you're just looking at the straight statutory text, you might say, well, it has the power to regulate all the things when it comes to workplace safety. And this is one of the all the things. But there is another doctrine in law called the major question rule, which is where if something is deemed a major question, otherwise broad grants of authority are not thought to encompass it. The idea being that if Congress really wanted to speak to those specific questions, they'd write specific legislation regarding it, right? All the things, in other words, does not mean all the things. It means all the normal things or all the many things, but it doesn't encompass these major questions. And one of the major questions as it relates to the OSHA mandate was exactly this, as it relates to health, personal health, the personal health as it relates to disease transmission, and particularly the mandation of vaccines. So one of the reasons that the OSHA mandate was struck down was because although OSHA has the power to regulate all the thing when it comes to health and safety, this is a major question. It's particularly in the light of the fact that the U.S. government already has apparatuses to deal with health. OSHA is within the Department of Labor. If you want to talk about health, you know who you could talk to? How about Health and Human Services? How about that department? That's what they do with their time. OSHA is not within Health and Human Services. It's within the Department of Labor. The CDC is within the Department of Health and Human Services, right? The National Institute of Health is within the Department of Health and Human Services. So it's like, well, if it deals with health, you would think it would be over there, not over here. And we already have something to deal with it. And so it's kind of the same problem in the Procurement Act. The Procurement Act deals with how to buy things. I'm just going to go out on a limb and assume it has wide authority. But again, it's like, well, we already have authority to deal with these issues in these other domains. It's not like multiple agencies or multiple departments can't have concurrent overlapping authority. They can. It's possible, and often happens for that matter. You can have multiple agencies that can speak to the same thing. But when something is specifically given in one domain, unless it's specifically given in another domain, you would try to go the other way around and you'd interpret against. So that seems to be what's going on here. It's like, the Procurement Act probably doesn't speak to, my ability to buy and sell things as a U.S. president. Probably doesn't speak to my ability to mandate vaccines. Kind of not in there, unless you got something a little bit more specific. The general authority to do all the things is not going to be read to cover that specific thing. So there's your legal rationale behind that kind of decision. Of course, this is by no means the only blow against the Biden mandates. This preliminary injunction that came up in this case is the latest blow to Biden's administrative efforts to push companies to make sure their employees are vaccinated. Well, to the degree that we're asking them nicely or encouraging them, the U.S. government can encourage anyone to do anything. That's fine. When we get to mandates, however, it's a whole nother set of problems. The Biden administration, of course, was forced to halt its vaccine and testing requirements of the OSHA for 100 employees or more because of these same issues, also citing serious constitutional concerns because on top of the statutory questions, right? So on top of the issue of, is this within the scope of the OSHA regulations, which was the issue we fell into with the CDC, where we said, no, your ability to sanitize things does not give you the ability to put in a renter's moratorium. It's not within the scope of the statute, right? Then we got into OSHA. It's like, okay, it's within the scope of the statute, at least as literally written, but still we have this other doctrine, major question issue, so it's excluded. Then if we got past all that, we still have another problem on top of that. We have constitutional considerations, right? For a couple of reasons. First of all, it's like maybe Congress is given too much authority to the executive branch and actually given them legislative authority, which they can't do. So that's a problem. Even if they have not done that, and even if that's not a problem, we then get into other constitutional problems with federalism, because the ability to regulate health is traditionally a state level issue, not a federal level issue. So we've got statutory scope issues. Even if we don't have the statutory scope issues, we have major question issues. Even if we don't have major question issues, we have delegation of legislative authority problems, and even if we don't have delegation of authority legislative authority problems, we have federalism problems with these mandates. The layers of the onion of the problems with this mandate do not stop at one step, my friends. They go many, many levels deep as we try to unpack all this stuff, particularly, as I mentioned, when it relates to federal government action. Federal government action. When it comes to state level action, it's an entirely different analysis. Entirely different analysis. So just because this is all happening with respect to Biden mandates doesn't mean you can just carbon copy all this and then go, oh, okay, I can just attach this to what the state of California is doing. No, my friends. No. Completely different questions. For the reasons I said, right? These are federal questions, and federal questions, we have all these issues. When it comes to state level issues, a whole new level of questions to be asked, my friend. But these are some of the many problems when it comes to the Biden mandate, OSHA, the Procurement Act, Congress, federalism. It's a long list, my friends. So that brings us to the end of this discussion of this article about how the court has halted the Biden federal contractor mandate to try to make all the contractors take the vaccine under the Procurement Act, which, as the name implies, is not the Take the Vaccine Act. It is the I'd Like to Buy Things Now Act. And the court says, the I'd Like to Buy Things Now Act probably doesn't tell you, doesn't allow you to mandate vaccines. Probably not what Congress had in mind when they wrote that. And even if they did, they didn't say it. And even if they did, it wasn't in the major question doctrine. And even if they did, it has a problem with legislative authority. And even if they did, it has problems with federalism. So, it's a long list. And at least for the moment, that brings us to the end of the discussion of this article. So many things. So many things, my friend. So many things, my friends. And this is where I, your friendly host, Uncivil Law, get to feel all warm and fuzzy about myself as a good legal educator, because I'm like, oh, okay, I know all these things from the top of my head, right? The article's not telling me anything. It's not giving me any information, but that's okay. I know what's going on because I have all this wonderful background information, so I get to tell you about all these different things, and I get to compare it to these other situations. I get to tell you about, legislative enactment. I get to tell you about federalism. I get to tell you about, about major question doctrine and all kinds of shit. It's nice to have all this background information, so I can just, pull that out of the air and pull that out of the air and pull that out of the air and be like, I can just pull these things out of the air and just bring them to you. Here they are, my friends. Here are these things that I can just hand you because I have them, to be able to be like, yoink, pull them out of the ether. It's great. It makes me feel good as a legal educator. It just makes me feel good because the article's giving me nothing, and it makes me feel like I'm doing some good work over here. So I feel very validated. Must be nice. Well, first of all, Tomorrow V, thank you. Oh, fount of legal background information. It's educational. Yeah. And Kevin says it must be nice. It didn't come easy. I mean, I've been a lawyer for 14 years. I've done over 1,000 cases on this channel. Right? It's like I have this knowledge because I've worked really hard to develop this knowledge. Like, I have over 1,000 videos on this channel. That's a lot of stories. I've been a lawyer for 14 years. I read a lot. I went to law school. I read a lot. I talk to a lot of other lawyers at our legal panel. I think a lot. I think a lot about these issues. So now it comes easy after the result of all this. It's like, it reminds me of the old story of a guy who's asked to fix a machine, and he comes to the machine that's malfunctioning, and he puts a little chalk mark on it, on the machine, and he's just like hit it with a hammer here, and someone hits it with a hammer there, and it completely fixes the machine. And so he sends a bill, and the bill is like for $1,000. And so the company sends back, it's like, well, you just came in and just marked it with a little check mark. How are you getting to $1,000? And so he sends them back a reply, and the reply says $2 for making it the check mark, $998 for knowing where to put it. And it's like, yeah, that's something like that. So yeah, anyways. I am in a decent mood tonight. Yeah, I'm in a decent mood. We'll take it where we can get. Only panelist doing the Supreme Court, man. I love doing the Supreme Court, man, because it's like, you can't. It's hard to play. It's hard to play on a level. It's hard to play on a level any higher than the U.S. Supreme Court, man. It's hard to play on any field higher than the U.S. Supreme Court. And I like doing the U.S. Supreme Court cases because it's like, man, I'm playing at the top level, man. And just be able to hold my own, or at least sometimes hold my own. It's nice, man. All right, let's carry on. For today's story, we are talking about someone who has an autistic son who has problems keeping a mask on, has to be able to travel to get to a hospital for treatment, and can't fly on an airline because they can't keep a mask on. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal educational content, and today may be the day I earn your subscription. For today's story, we are talking about airlines and masks. As we have discussed on this channel before, federal law governs the flying of planes because they fly across state lines, right? So how we deal with the airplanes, well, that, is federal law for a large part. So federal law says you have to wear a mask on an airplane. Okay. But then, of course, there are some problems. How about people who can't wear masks on airplanes? How about them? And we have such a situation, at least arguably, in play, where we have a person who's 4 years old, who has issues with autism, and because of this, has trouble keeping the mask on their face. And as a response to this, has been kicked off flights and not allowed to board flights, which is a real problem for this child because they can't fly to get to the medical care they need because of the specialized medical care they need to get to the hospitals that can treat them. So we have tension of whole kinds of things. So we're going to read this article and learn a little bit about what's going on. The father of a 4-year-old autistic boy said that his son was banned from Frontier Airlines for life because he cannot bear a mask. Now, first of all, the fact that we're banning a 4-year-old for life is kind of like, he's 4 years old and we're banning him for life at 4. There's something that's just wrong about that, on the first blush. He's not an adult. So he's not even close to an adult. He's 4. So this kid receives medical treatment in Boston and has been blocked from getting on these flights twice because he doesn't wear his mask. His father is suing the TSA and 2 airlines over their policy. He says his son is medically exempted from wearing a mask, and he has presented doctor's notes to the airline workers. The father says he's been banned for life from Frontier Airlines. I was specifically banned as well. Incredible. Explain that he's seeking a Supreme Court intervention in this case. He's trying to. I don't give him high hopes of that because of the odds of it normally, but you know. He also slammed the appalling and condescending treatment from airline workers when he explained the situation and provided the note. It's just totally mind-blowing to be refused travel for that medical care. This is sick. This is child abuse, Ingraham responded, saying that companies are running scared from liability. Well, that's fair enough because they have a mandate that's been imposed on them from federal law. So their attorneys obviously are going to be cautious about it because, you know, they want to be compliant with the federal law. The boy's parents say that his son cannot tolerate the mask on flight. And he said that the doctor's note do not override corporate policy. So corporate policy might have a different mechanism than just simply submitting a doctor's note. You know, there might be a formalized mechanism to go through. And that formalized mechanism may or may not comply with federal law. Merely showing up with a doctor's note may not be sufficient. So if their corporate policy is, you know, if you just show up with a doctor's note, we're going to refuse you, that may not be in compliant with federal law, including the Americans with Disabilities Act. Americans with Disability Act, of course, only requires you to give reasonable accommodation. And that doesn't necessarily mean that just because I show up with a note that day, which incidentally, they have no particular method of validating on the fly, that might not be sufficient. So, you know, they might have a policy otherwise, which might be fully compatible. And so there are problems here in terms of getting these masks and making sure that they're compliant and things like that, and the process in hand. And I think there was another article about this that I wanted to read as well. So let me see if I can find that real fast. Flower says, have a nice night, Uncivil. This chat is not for me. What is going on in chat that's a problem? What is going on in chat that's a problem? Are we not being polite to others? Are we not treating each other with respect? Scientifically illiterate climate deniers? Well, we do allow a wide expression of opinion as long as it's on topic. And we do require people to be polite to each other. All right, Stephanie's got it. That's cool. All right, Stephanie, I'll let you take care of it. I don't know if that story will be cut up. I'm not sure there's not enough there for a edited story. Liquid water takes up more volume than solid water. I don't think that's true. I'm pretty sure it's the other way around. Solid water takes up more volume from liquid water. That's one of the reasons that the density goes down and the reason it floats. Yeah, that can't be true. That can't be true. Solid water takes up more volume than liquid water. Yeah, I know that's true because if you take a bottle of water, if you take a completely full bottle of water and you put it in the freezer, the bottle will expand. It will bulge out because the solid water takes up more space. Right. Solid water takes up more volume than liquid water. Of course it does. The same amount of water takes up more space, therefore the overall density decreases, therefore the ice floats. Solid water takes up more volume, not less. Yeah, solid. When it freezes, it expands. When it freezes, expands. It doesn't contract; it expands. It's one of the few substances that does that, incidentally, and that's one of the reasons that ice floats. What about ice 7? Okay, guys. Obviously, we're talking about the normal kind of ice. If you guys want to start talking, okay, the fact that I understand what you're talking about when you say ice 7 is disturbing. But I guess just goes to show that how much I read. Okay, yeah. So there are different kinds of ice. There are different kinds of ice. This is true. There are different kinds of ice water. For ice water to be other than the normal ice water that you all know and love, some very strange things have to happen. Like, these only happen under basically laboratory conditions where you can do some really strange shit with pressure and shit, and you get like different forms of water and different forms of ice. Because like things, I don't completely understand it, but if you do it just right in the lab and just the right way, you get like different versions of ice, and the different kinds of ice act differently. We're talking about ice. We're talking about the kind of ice that forms, on the Earth. Not in some lab experiment where you have precise control over volume and temperature and, pressure and, we're talking about normal ice, not special ice. Oh Lord. Yeah, if you have the special ice, it may sink. I don't know. I have no particular claims about the special ice. Oh Lord. So that brings us to the end of the discussion about this father who's having problems with his autistic son. I can't speak to the degree of autism, and I can't speak to the degree to which he has gone through any formalized process that's been made available by the airline or otherwise, or how effective those processes are. But I have no problem in believing that merely showing up with a doctor's note is not going to cut it. Because, how would you know it's from a doctor? How would you know it's authentic? And all the rest of it. How would you be able to validate that? I'm sure there's some sort of more formalized process if you're going to get some sort of exemption. And how good that process is or otherwise, I don't know. But I would imagine it requires a little bit more. So I don't have particularly high hopes for his ability to get Supreme Court review. Not for least the reasons that it's not immediately clear that he's followed whatever process is in place. But at least from the moment, that brings end discussion of this story. What about nuns? Ooh, what about nuns? Do we want to talk about the technical difference between nuns and sisters? Yeah. What is the technical difference between a nun and a sister in the Catholic Church? I'm so glad you asked, because I know these things because I read way too much. Yeah, a nun has taken I forget the name for it, but they take the more formal vows, and a sister only takes simple vows, not the more complete full vows that a nun takes. So the vows a sister takes allows for ownership of some limited property and stuff like that. It's a less rigorous form, and that's the difference between a nun and a sister in the Catholic Church. Also, we have to be even more specific than that, because we when we say Catholic Church, we have to be more specific, because what do we mean by a Catholic Church? Well, my friends, we typically mean the Roman Catholic Church, because unless I be overly unless I be unfriendly to my Catholics, of like the 38 other versions of Catholicism that there are. Because there are like 38 different versions of Catholicism. When we say Catholic, we normally mean Roman Catholic, and not the 38 different kinds that you might also be. So your mileage may vary if you're not part of the Roman Catholic Church. Yeah. So good times. Good times here on Uncivil Law. We learn some ecclesiastical law along for the ride too. Married priests can exist if they're married before they're converted. This is absolutely true. That is correct. You are 100% correct, Sarah. Yeah, this it's funny that it's funny that Catholic means universal and there's 38 versions of it. That's a funny thing too. It's just these random too many things. If a man wants to be a nun, can that be arranged in 2021? I bet you it can. I bet you it can. That's kind of hilarious. For today's story, we are talking about vaccine mandates, this time being imposed by New York City on all private sector employees. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today may be the day I earn your subscription. For today's story, we're talking about a new vaccine mandate that was put in place by the New York City mayor, who is leaving office at the end of the month and is putting in place a new mandate that begins on December the 27th, which I would take note is 4 days before the end of the month. So on his, fart in the elevator and walk away strategy, the mayor of New York has put in place a vaccine mandate that is going to apply to all employers within the great city of New York. So let's learn a little bit more about this vaccine mandate that's being placed. So this is coming in place and applying to 184,000 businesses in New York City. From the big Wall Street banks to corner grocery stores, all private employers in New York City will have to require their workers to get vaccinated against COVID-19. The mayor, who is leaving office, announced Monday in the most sweeping vaccine mandate of any city or big city in the U.S., or any state or big city. The move by Mayor Bill de Blasio, soon to not be mayor, as cases are climbing but little understood, says, we in New York City have decided to use a preemptive strike, which, I'm not sure that's exactly what preemptive strike means when it's 2 years after the fact. It's a very strange meaning of preemptive, but whatever. It's a preemptive strike to decide to do something really bold to stop further growth of COVID and the dangers it's causing all of us. De Blasio, with just weeks left in office, well, not really, it's days really at this point. The mandate takes effect December 27th, just before he leaves office. All in-person workers will need to provide proof they've received at least one dose of the vaccine and will not be allowed to get out of the requirement by agreeing to testing. So all vaccine mandate all the time. For you, those of you who want to appear in person in New York City, which should be no problem at all, because it's not like people have been trying to flee New York City in combination due to overly onerous restrictions or the price of real estate or any number of other factors. So I'm sure this will be great. This will apply to all 8.8 million people in the city, or about 3.7 million of them who are in the city's private workforce. And anyone 12 or older who wants to dine indoors at any restaurant, go to a gym, see a show, will have to have proof of receiving 2 shots of the vaccine up from the current dose of 1, and children 5 to 11 will have to show proof of at least 1 shot. So all this stuff. So there's this guy in Brooklyn who runs a grocery stop, saying it puts him into a bind by forcing him to fire employees. Everyone wants to do the right thing, but the right thing is different for everybody. I respect everyone that says they don't want to take it. Well, you don't have that ability to respect anyone anymore. And of course, President Joe Biden, of course, sought to do this by OSHA to 100 employees or more. But, OSHA's federal and this is state, so that's different analysis. It also notes that 5.9 million adults in New York City have gotten at least a first dose, out of 7 million people aged 18 or up. So about 84%. So it's not even clear who we're trying to really mandate at this point, because 84%, it's a lot. But they still get 2,000 cases a day, even after they sent all the elderly people with the COVID back to the nursing homes to infect all the old people to kill off the entire elderly population, which is definitely a thing that happened there. And it is required also for hospital and nursing home workers and for city employees as well. So that takes care of a large portion of the other workers. A. Hedinger, I'll take care of that. Point of order. This is municipal, not state, isn't? Well, it's state for our purposes, and I'll clarify that in the closing. But it's a fine point to make. So that brings us to the end of discussion of this case, or the end of the story dealing with New York City. So as we've discussed many, many times, when we talk about federal versus talk about state, we're doing two different kinds of analysis. When we talk about federal government, like through the OSHA mandates or CDC or things like that, we have a whole bunch of concerns. Congressional authorization, major question doctrine, doctrines of federalism, all the rest of it. But when we're talking about state level action, we don't have those problems. And in fact, Jacobson versus Massachusetts itself started with a city level action, namely the city of Cambridge, which in the early 20th century put in place a mandate as it relates to smallpox vaccines. So this is much more on point with the case law. Now, I said state level mandate, and you might want to know, well, why is that? Why do I talk about state when we're talking about New York City, which is a municipality? And the reason is because as far as the structure of government's concerned, we only really care about federal and state level authority, because cities have no authority other than what the state gives them. So when we talk about state level government, New York City, for the purposes of this analysis, is a state level government. Their ability to do this is authorized by the state or not, and they have no independent authority to do this other than the state may give them. They are but creatures of the state, manifest to the state's will. The state legislature can do anything they want or not, and so the fact that this is coming from New York City as opposed to the state of New York does not really have any impact on our analysis. We could say whether or not the city of New York has the power given to them by the state of New York, but ultimately it's a state level power regardless of whether it's the city or the state issuing it. So that's why I say the state, even though it's because this is state level power one way or another. It's state level power through authorization or otherwise. So that's why we said that. But yeah, this is Jacobson versus Massachusetts all over again. Or at least it's the same issue. Obviously, in Jacobson versus Massachusetts, when you're talking about the smallpox that kills 30% of the population, a little bit different than COVID, arguably, but that's the case law, at least today. So New York City's mandate is on much more solid footing than anything that the federal government has done. That isn't, of course, to say it isn't assailable, because, as I say, Jacobson dealt with a much different fact pattern and also was rendered at a time outside of our current constitutional analysis structure. So when we didn't have the tiers of scrutiny, this came way before that. So Jacobson is currently sitting outside the current constitutional structure, and it was based on a different fact pattern. So there is avenue to attack it. That being said, of course, Jacobson ultimately is a U.S. Supreme Court case, and so only the U.S. Supreme Court can really overrule it. But it is assailable, but it is much more in keeping with the case law as it exists right now. But unless this goes to the U.S. Supreme Court, that will bring us to the end of the discussion of this story. The vaccine is no longer in the testing phase. It's gotten full FDA approval. It's no longer The vaccine is no longer under experimental use authorization. It received full authorization quite a few months ago. Yeah, that's no longer a thing either. Someone says the approval was rushed. Maybe it was, but either way, it's a different legal status than it was. So, I don't know about that, Roosevelt. I don't think that's true, but FDA approval was for commonality, not the Pfizer one was available. I was under the impression that the name was just a different name for the same thing. I don't think it's a different formulation. It might not be being sold under that brand name, but I think it's the same formula. It might not be in the same packaging, but I think it's the same medication. But I couldn't swear to it for absolute sure, but that was my impression at least. Hey, look, you don't have to convince me about problems with Jacobson as it relates to eugenics. You're right. It was a backbone of Buck versus Bell. You're absolutely correct. It's murky. Let's take a look at this FDA release. I mean, I'm not all the expert, obviously. So it's going to be marketed as Carmidity. So it was approved for full use for 16 and older, emergency use for 12 to 15, which I think has since also changed. Yeah, the vaccine has been known as the Pfizer BioNTech COVID-19 vaccine and will now be marketed as Comirnaty. So I think it's the same drug. It was just changed with its name. Okay. So the emergency use authorization remains in effect for the 12 age and older. 2-dose series for 12 age and older, third dose for 12 age and older who've been determined to have certain kind of immunocompromised. So I think it's the same drug. The FDA approved vaccine and 2 EAU authorized formulations used interchangeably. The products are legally distinct with certain differences that do not impact safety or effectiveness. Yeah, but legal distinction doesn't. They're legally distinct in what way? Because of the packaging, or legal distinct and formulaically distinct are not the same thing. I'm not sure, man. I'm not sure. These articles at least are not telling me off the top of my head, and I'm way too tired to figure this out right now. The FDA approved version is non-production, not available. You're getting the EAU version, which is not FDA approved. I'm not sure if that's true or not. I mean, I don't know enough to disagree with you. Yeah, just a name and package change. I think that's correct. If Comirnaty is approved, Moderna and J&J have to be appealed under EUA. Well, that is typically true because EUA does technically mean that there's no drugs that would be sufficient. So that would be the normal response. Yeah. So it would. I mean, that is the normal rule for EUA, is that there's no other drug that would work. So if that would be the logical result. You would think that if it was approved, it would mean that those were withdrawn, but they're not. But I don't know the full details of the EUA and the degree to which that can be suspended or not by rulemaking. So, yeah, no alternative. Please see your super chat. Robert Boards has a case against the military because FDA approved drug has not been produced. I don't know anything about that. And I'm always just a little bit skeptical of Robert Barnes, but that's, you'd have to you can base your own opinion on that. Anyways, where was I before we got too deep into that thing? Yeah, I that's my understanding, Matt. And that's my understanding, is that they are biologically and chemically the same thing. And the legal distinction comes from the labeling and packaging, not from the actual formulation. But, why skeptical of Barnes? I don't want to go into that right now. Okay. All right. Okay. All right. All right. So I think we're going to end with this story. Yeah. Yeah. Barnes. Yeah. That's a good way to put it, Matt. That is a very good way to put it. Barnes is a very good advocate of his position, regardless of how legally sound that position is. So that's a good way to put it. Yeah. He's a very good advocate. And he's a very good advocate no matter how legally sound what he's arguing is. So that's a good way to put it. Yeah. All right, so we're going to end with this story, and I just want you to know that the tentative working title of this story, and almost certainly the title I will use on this video, the title I will use on this video is 45 ACP D's Nuts. 45 ACP D's Nuts, I think, will be the title of this video when it releases. For today's story, we are bringing about equality among the sexes. We recently covered a woman who pleasured herself and managed to shoot herself in her own vagina. But today's story, it's the boys' turns. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you will enjoy this legal education content, and today is the day I earn your subscription. Yes, my friends, the stupid knows no gender bounds. It knows no gender bounds today because, whereas before, a woman decided to please herself with her loaded 9mm, the guys decided to one-up themselves. Instead of 9mm, how about 45 ACP? And instead of a vagina, how about my balls? You're breaking my balls. Yes, I am with a 45 ACP. Let's discuss this story. Yes, a guy has an online group that points a firearm at his own genitals has a predictable accident. A member of a Facebook group dedicated to men who get their rocks off by posting photos of loaded guns pointed at their privates got a bit trigger happy and actually shot herself in the junk. Okay, my friends, time out on the uncivil law. Time out on my uncivil law. Okay, apparently there is a fetish group on Facebook, and this fetish group is of the nature of men who get their rocks off by posting pictures of loaded guns pointed at their privates. The stupid is very, very real. The stupid is so very, very real. So very, very real. The unidentified member of this group, loaded guns pointed at, from the San Diego area, pointed a video of himself pointing his .45 caliber M1911 semi-automatic as genitalia. After a brief pause, the gun went off. "Hey boys, I might have effed up," the man wrote in a gross understatement above a photo of a towel stuffed between his legs, along with blood spattered on the floor and a copy of the Constitution. The outlet reported, well, you know, I have to say I've never really considered that question before. That's a new one. I've never really considered what the Constitution has to say about pointing a loaded .45 1911 at your own balls, but apparently he's thought about it because he has a copy of the Constitution blood spattered on the floor with the result of his own work. So, good times. Wow. The original footage and subsequent thread was deleted, but the group's members later uploaded the gory mess again. As he bled, the man wrote, "God's caliber, 45, went through my scrotum, mattress, box spring, and floor." He thought at first the round just grazed his testicles, which, with a 45 ACP, okay, but Raven found out about the damage at the hospital, where he posted a photo of himself in a green gown while lying on a gurney. Turns out it wasn't a graze. The round went right effing through me. What I thought were 2 graze wounds turned out to be an entrance and exit wounds. You're busting my balls over here. You're busting my balls. With a 45 ACP. Went right through it, man. Oof. An administrator for the Facebook group, which rewarded that knot by making him an admin himself, told Motherboard he's 100% okay. He went to work the next day. Okay. The reason we're calling him a king is partially because the poor guy already shot himself. Don't think he needs to be chastised as well. I'm quite sure he learned his lesson without the entire world calling him an idiot. In one meme created by the group, which changed his cover photo to a screenshot of the man pointing the gun at his penis, Barack Obama is seen as giving him the Presidential Medal of Freedom. Wow. Okay, fine. So that brings us to the end of the story of a guy who decided to one-up our recent cam girl, who decided to please herself with a 45. This guy knowingly and purposefully and with intention pointed a loaded 1911 45, which is God's caliber, at his nuts. And apparently God does not want him to procreate because he shot himself right through his own nuts. So, and apparently there's a Facebook group devoted to people getting off on pointing guns at their loaded genitalia. So, again, I don't know why I have to tell you guys this, but I'll tell you it anyway. Rule number 1, the gun is always loaded. Rule number 2, perhaps the most important in this particular description, don't point the gun at anything you don't wish to destroy. And rule number 3, keep your finger off the trigger until you're prepared to fire. These rules were all very, very violated. Very, very violated. Not as violated as his nuts were. And that brings us to the end of the discussion of this case. We're sorry. The uncivil law that you've tried to reach is disconnected or no longer in service. Please try the number and try your call again. Message 45. The uncivil law you've tried to reach has been disconnected or is no longer in service. Oof. 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 Well, my friends, that is the end of our recording stream tonight. That's the end of the recording stream tonight. Rule 43, Q squared, and then $5 from Super Iron Bob. I have screenshots of the post if you want them. That's okay. I think I'm going to pass on that one, but I do appreciate your enthusiasm for it all. Do we have any good nut jokes? Because at the end of the stream with the woman, we had lots and lots of great jokes. Do we have lots of great jokes that I can do for the nut jokes? Guys, this is where you have to pop in with your jokes so that we can balance out the jokes that we made at the woman's expense last time. So let's do some jokes. Okay, so it's time for joke hour from the chat. Rod and Gun Club, that's good. Redefining blow your load, a little bit. Forrest Gump Ian, that's pretty nice. From Crypt to Eunuch, nice. Balls, no balls. You know, Nick Rikita would be very, very proud. Yeah, this is the ultimate answer to balls, no balls, I think. This guy has answered all those questions forever. The right to bear before arms. He will have a blue Christmas. Good one. The question is hollow point or ball ammo. I think we know the answer to that one. When he can't get a vasectomy for cheap enough. Cyclops. A real ball buster. The blood on the Constitution was real this time. Man solves nut allergy. Dude thought he was a baller. Guess he got shown. A real nutcracker. Ballsectomy. Unloading takes balls. No Nut November world champion. I think we got enough of that for now to end the stream, so we can have our balance in our jokes. No Nut November got real. All right, guys, I'm going to sign off for now. I hope you enjoyed this stream. As always, I'm going to sign off. I may record some tomorrow. I have work to do, but we'll see. But until later, my friends, I hope all's well. Cheers and goodbye.